obviously the defense objected to going into this unregistered gun in the beginning. Just got in, the state asked it. I asked some follow-up questions on it. The state knew all these things about what she had told them about this particular incident.
I don't handle guns like that.
How big?
You said guns like that. What do you mean?
Meaning, I don't know. Meaning, I'm not familiar with guns like that, but I can tell you there was one.
What color was it?
This big? Was it this
Black.
big?
Was it long, short? Can you describe with your hands?
It was short. It wasn't. It was probably a pistol of some sort. I'm not sure.
Okay, where did you see it?
It was at the Mech One house.
So you say that this unregistered gun is in California to law enforcement. Up until today, did you ever say anything about this gun being in Wisconsin?
When I had talked about this gun, there were other traumatic events going on in my life. So this isn't.
You don't have to defend your answer.
I'm trying not to defend it. It's what happened. It's legitimately what happened. Like, there were other things going on, and this isn't something that's related even to this situation.
But
Yeah, you made it related.
It's not.
I'm not. Don't take this as a scolding. I'm saying, listen carefully to the question and just try to answer just the question. And if there's more to be gone into, the lawyers will usually cover it.
I was threatened with that gun, for your information.
Judge, I'm going to ask that be struck. That wasn't my. That wasn't.
No.
Repeat your question.
Repeat your. Who's she?
It will come as no surprise to you that you're
What?
going to go into the library for a moment.
What the heck?
Wow.
Actually, the question right now is whether you want to agree to.
I do want to agree.
No.
I was just trying to make a record, Judge, from the defense's perspective of the state. It's fine. It won't need it.
I applaud you for making your record
Thank
as an
you.
attorney, but I also put in this stipulation.
Stipulation means they're
that
consenting.
This closes the matter out.
That's what you shouldn't
it's,
stipulate. Don't stipulate.
It's not going to be the subject
No.
of any
Stipulate.
attention
You're
from the
losing
court
case here
hereafter.
on this potentially.
If everyone agrees it's irrelevant, that it's to be disregarded, and it is, that's in no way suggesting the child has not testified truthfully, only that any threatening behavior does not involve the defendant.
That's not true. The threatening
That's not
behavior,
true?
the threatening behavior is alleged to be from the defendant.
Not according to the testimony.
That's not what
That was not the testimony.
What
So
was the testimony?
the testimony was that she was threatened. She didn't say who, she didn't say anything. There's no factual basis for
Everyone
that whatsoever.
thinks-
That she was threatened with that firearm.
With this
He
firearm.
said she was threatened with that firearm.
There's an inference
Then I
that if the
excuse
firearm
the jury.
belonged to him and she was threatened with it, that he was the
And
one
I
holding it.
did not, after that, hear any reference to the defendant having been associated with a threat.
Okay.
And I
They should clear
interpreted
that up
what
with
you
the
said to
jury.
me,
Absolutely.
confirm that. And then I thought, well, he's the DA. He'd know, but of course, you weren't the DA of wherever the threat allegedly took place, which is, quote, Wisconsin. But
You need to clarify.
Okay. Well, so the current state of the record is she says, I've been threatened with this firearm, but it doesn't say who threatened her.
correct.
I see.
So I intend
Is that
to.
your recollection as well?
Move for a mistrial?
I took it as that she had said he threatened, but I may be wrong.
I think
Well,
that was wrong.
I don't recall
Okay.
hearing that.
Well, go back to the transcript because
Okay,
the jury's going to
She
be
said
on
I
the
was,
No,
I was threatened with that gun.
you're never wrong.
I'm not used to being
No.
told that.
No, I would never, ever suggest that.
Why not go back to the transcript? and
But I
see
think
what
the
it
way
says
you
potentially?
phrased it was accurate to sort of summarize it for the jury and then say disregard it and it's irrelevant to this case.
Summarize that she never
Okay,
said
I'm
that he
try
made
it
that.
again
We have
now.
no
And
idea
this is
if it's.
if you agree to it. If you don't agree to it, by the way, the alternative is that we'll have to address it. I can't just leave it out there.
Don't agree. Don't agree. Don't agree.
So
Don't
what I
agree.
propose to do is to tell the jurors that the last response that was made by the witness, we've examined it and the circumstances, that it is irrelevant to this case, and there was no accusation as to who,
Oh, come on. Everyone's going to think it was him.
whose
It's his
conduct
gun.
she was
His
describing
daughter. Come on.
when she referred to having been threatened.
And it's such a powerful statement. You can even visualize. They see the girl there. They can even visualize probably him holding some gun and threatening her with it. It's terrible. Oh my gosh.
At all. So I don't. If the court saying that because you think it provides them some ballast for then what we do? Because I as far as I know, we have not examined the details of what she is saying happened in that regard, right?
Well, first of all,
I mean, I've just.
First of all, if we do examine it and it turns out it does involve the defendant,
Right.
tell me how to avoid a mistrial.
Yeah,
Yeah.
no, I understand. I'm just
Okay.
trying to get wording that is fair. I got where the court is.
Stand up and demand a mistrial.
Cleaner way to
The
avoid a
judge just
mistrial.
told you stand up and demand a
Just
mistrial. I'll
strike
overrule you,
that
and then you can
entire
appeal it.
question and answer, period.
About the
And
unregistered gun.
yes, the reference to the gun, and just strike it completely.
Oh God.
So we don't agree to
Are
that,
we
but
living
we
in
are
La La
willing to
Land?
strike the last question or two.
No.
But the unregistered firearm was brought up, and the court has already given a cautionary instruction to the jury verbally about that. So they brought up, they opened the door. The state is not willing to leave a discussion under cross, as we described before, where the accusation is that there's improper discussion when there is an honest answer. But if we wanted to simply go back a couple questions in the inquiry from the defense and
Yeah,
strike
let's just
those,
unring that bell.
and
That bell's
indicate
totally
the jury
can
is
be
to
unringable.
ignore those questions and answers.
Oh yeah, it can
I'm
be
agreeable
completely
to that.
ignored. It's just
Let's
it's
just
done a
have
brilliant
Mulligan.
job covering that
We'll
up.
just.
What the?
What happened?
Other acts evidence coming in when the
Bloody learn
state
from, I tell you.
talked about how they want
You
to
need
ask
the cut
about this
cage.
gun. And the problem with them knowing
Yeah,
this
but if you put it on, then it covers
information
me.
because of a conversation they had, and the defense then left in a situation where the jury hears about an unregistered gun. Maybe I should find out a little bit more about that. And then it leads into this. I think because the witness has testified that Mr. Anderson had an unregistered gun in California and has now said that when this gun was here, allegedly, she was threatened with it, that the inference that's going to be left with the jury is irreparable if we do not
Mistrial.
strike everything about that
Mistrial.
unregistered firearm.
No, mistrial. You can't. Striking
Well,
does nothing.
No.
Call for a
I
mistrial.
don't agree with that, about the irreparable part. I don't agree with Mr. Gravely's suggestion,
So
because
close to
I
doing
did
this
think
properly,
that, well, I'll
and
leave that at that.
disastrously doing it.
I am going to tell the jury that the last remark, which was made by the witness, does not relate to this case. She did not identify
I'm actually gonna see if I can wake Jeff up.
any specific person as having threatened her with a gun. And so it should not form any part of their consideration about this case.
This witness got brazen with him, and he just cucked into it. Wow. No, this is so not good enough. Not even close to good enough.
No, it's really not. I'm furious. This is a mistrial situation. I mean, this whole trial is a fucking mess.
You ask for a mistrial, you lose on that application. At least you preserve it. But this
Yeah.
judge basically even told you He even planted the seed in your mind, telling you that this is irreparable harm. I mean, and saying, "Oh well, she never said it was him who did it." That's the jury's
Doesn't
going to be
matter.
like, "Yeah, who the hell was it if not him? It's his gun, his daughter. Please, we're going to pretend we didn't hear that."
Right. As the designated layperson here, like,
Mhm.
you know it was his gun. You know that it was likely him. So
Who
saying that
else would
does
be
nothing.
threatening him with that gun?
Right.
What do you think? It's missing Gutierrez who found that gun and was threatening her with it. Please.
Yeah.
And also, do we have evidence or proof that the gun even
It is
exists?
appropriate to share with you, and
there's
there
no-
may not be.
There's nothing you lose
Then you-
nothing by
then you'll
moving
know
for
more.
mistrial and being
Or perhaps
denied.
you won't share
At
any.
least you
We'll
preserve
find
it.
out.
It's
Just on
stipulating
the point
waives your
of
right
the
to appeal this.
court's proposal, and
All right, Jeff's on his way.
I think the
Just in
addendum
case.
to that, excuse me, would be to not only give that instruction as to however many questions it was, but also to, because there's a serious slippery slope taint here, suddenly introducing a firearm into this, and to prohibit them from arguing about the firearm in their closing. Even though it's apparently some of that.
I don't want to get into a negotiating session and try to handcuff the district attorney. Either you agree to it or not.
Well, let's
And we talk
Not.
with Mr. Barth.
Not.
confer.
And I will tell you, as I said a moment ago, one of the possible outcomes of this.
Good
is a
question,
mistrial.
Kat.
I'm not telling you it will be. I would sleep on it before I make a decision like that.
You should sleep on it
And I
before you make a
probably,
decision like saying I consent.
Wouldn't want to do a cram down on anybody either, but be
Yeah.
aware you may end up there.
Understood. We'll confer.
All right.
Break for the day. Come back tomorrow.
Hey, if
Really
you
think this
don't
one
mind
through
the jury's
defense.
overhearing what you say. No, they're
Rob, come
yeah.
here, join us. We want your input.
Oh, you
Is it
son
just
of a...
me?
If Nada was here, I'd be like, "What's her cell phone number?" I'm gonna start texting her. I'm gonna start texting this defense counsel, screaming, "Mistrial, mistrial, mistrial." No.
Why are they not
stipulation.
asking for one?
We should-
Oh my god.
I don't have Natalie's number. I'd be yelling at her to like text her. You damn well better demand a mistrial.
If
There's
this isn't
no
a mistrial situation.
downside. There's no downside. There's nothing
No.
you can lose. I mean,
She
worst
might as
case
well take a
scenario.
swing at it because it's. Oh my god.
The only way you can an appeal, in case any of you are confused about the way our judicial system works, an appeal only works if you make an application and that application is denied. If you stipulate, what that means is, well, we haggled it out, and this is what we all agreed to. Once you form that agreement, there's nothing that you lost on that you can then go to an appellate court and said, wait, this was a terrible thing that never should have happened in the trial. So every time you're sitting there and being all congenial and saying, oh, yeah, I guess this is fine, I guess this is fine, you are sacrificing your client's ability to raise that issue and appeal. And on something like this, if you think for a second, if you can fool yourself into thinking that this jury, that all they're going to remember from today, the only thing they're going to remember from today is that defendant threatened his own daughter with an illegal gun. That is what they're going to take from this. And we know we're supposed to ignore it, but that's what he did to that little girl. That's what they're going to picture. And now we need to decide whether he also killed this guy, his ex-wife's boyfriend. Please. This is a terrible, terrible, terrible thing. And this has to be a mistrial.
If this is not a mistrial situation, I don't know what is.